It's my pleasure now for George and I to introduce our keynote speaker for the conference, Judge Matthewman. If you could join us, please. It's a distinct pleasure for George and I to introduce Judge Matthewman as our keynote speaker. Judge Matthewman and I actually were in the same graduating class at the University of Florida Levin College of Law just a few years ago. And Judge Matthewman has taken the lead in writing articles and writing decisions in e-discovery. In fact, most recently, he published at the University of Florida Law Review an important article on the new paradigm change, which is really the foundation of what we'll be talking about for most of the day today. So Judge Matthewman is going to give us our keynote address, and then he'll be joined on stage after his keynote address with other members of the judicial panel to talk about many of the themes that he is going to address right now. So, Judge, welcome, and thank you very much.
All right. Good morning, Bill, and good morning, everybody. It is a real honor to be here today. And I will tell you that it's a wonderful day for an e-discovery conference. I think the fact that approximately 3,000 attendees have registered for this conference shows just how important and how necessary and vital e-discovery is in present-day litigation. UF Law puts on a great e-discovery conference each year, and this year is no exception. I am truly honored and humbled to be here to address all of you at this virtual, completely remote, completely free University of Florida 2021 e-discovery conference. Now, this conference is being held, as you know, after a year like no other. The COVID-19 pandemic has had a tremendous effect on our society, on people in general, on our institutions, and on our legal system. It has required all of us to be flexible and to adapt to the changing landscape. The COVID-19 pandemic has certainly had a great effect on lawsuits and litigation. Depositions are being conducted remotely. Hearings are being held remotely on Zoom and other platforms. In some cases, trials are being held remotely. We are all working remotely. These are all very rapid changes which we have gone through in 1 year, which we could not have anticipated a year and a half ago. Technology has greatly assisted us in being able to keep our courts open and working. And of course, technology and e-discovery go hand in hand. I think that many of the technologies that we have used, literally have been forced to use over the past year to keep our courts open and running, such as, for example, remote hearings and remote depositions, are here to stay in some form or fashion for the long term. They aren't completely going away when the pandemic passes. I am pleased to be part of this conference, which embraces technology and aims to enhance the e-discovery legal abilities of attorneys and others in our legal system. I know that in past years, when I have attended this conference, I have always learned a great deal from all the presenters, from the experts, from the sessions, and from the audience. I look forward to learning more today. There's a lot of knowledge and insight you will hear, and a lot of tips you will hear throughout the day today. And I am looking forward to providing you with any modest tips or insights that I might have to help you better deal with e-discovery in your profession or job. I am hopeful that this conference can provide you with tips that will make you work smarter, not harder, and make your professional lives better. Now, in my career, I've been around an awful lot of litigation, a lot of trials, a lot of discovery, a lot of e-discovery. I am now in my 9th year on the federal bench, and before that, I was a very active trial attorney for many, many years. In my prior life as an attorney, I handled thousands of cases, both criminal and civil. I tried many state and federal cases, many jury trials, many bench trials. Some of my trials lasted 2 hours, some 2 days, some 2 weeks, some 2 months, some 6 months, some up to 8 or 9 months. One year, I tried 3 back-to-back federal trials, which kept me in trial and in court virtually all 12 months of the year. I tried state and federal murder cases, state and federal death penalty cases, racketeering cases, public corruption cases, all types of criminal and civil cases. I had high-profile cases that were on Dateline, 48 hours, carried live on in-session court TV. In my current life as a judge, I have dealt with a very large number of civil and criminal cases and matters, presided over civil jury trials, bench trials, evidentiary hearings, numerous e-discovery disputes, summary judgment motions, settlement conferences, on and on. And I think that these years of experience have given me some insight into our legal system as it relates to this conference, into e-discovery and discovery best practices, problems, and pitfalls. From these experiences, I think I've learned a few things. First of all, discovery and e-discovery is very, very important, indeed critical, in reaching a just and fair resolution of a civil or criminal case. It is a very, very important part of litigation. I can recall, for example, one homicide case that I handled as a defense lawyer, a murder case, where after reviewing all the e-discovery, all the photos, the autopsy report, the materials with my defense medical examiner expert, we decided that we should ask the judge for permission to let my expert go to the medical examiner's office and collect additional tissue samples from the deceased remains, the tissues that were saved, to try and determine why the alleged victim died. My client was charged with murder. Our defense was that his spouse, the alleged victim, died of natural causes, and the stakes were very high. The judge granted our motion. My expert collected samples of the saved tissue at the medical examiner's office and determined that the alleged victim had myocarditis, a heart condition, and died a natural death. After an approximate 2-month trial, the jury agreed and acquitted my client, found him not guilty, and he would be sitting in prison now but for that additional discovery. And in civil cases, I have seen discovery, especially e-discovery, emails, chats, messages, documents with metadata, produce fair settlements and a fair verdict, fair decision. And I'm sure that each of you can think of examples of the importance of discovery in civil and criminal cases. So it is clear that discovery is very important. Second, another thing I have learned is that as a practical matter, nowadays, all discovery is e-discovery. Gone are the days when opposing counsel would simply direct you to a file room where you could sit down and go through the files and boxes of documents related to a case and make copies of what you needed. Instead, discovery today is digital, electronic, extensive data measured in bytes and gigabytes and terabytes, produced in native format, reviewed on secure servers or hard drives, using machine learning, search terms, keywords, artificial intelligence, collected and analyzed and ultimately produced, but only if it is relevant, proportional, and non-privileged. It is e-discovery, electronic discovery, and it is not going away. Data is increasing rapidly. Each day there are new apps, new data being produced daily. It all becomes e-discovery. Therefore, in order to be an effective attorney, paralegal, or whatever your role is in the legal system, you really do need to know, understand, and feel comfortable with e-discovery in all its forms. And those of you who are attending this conference are to be commended to taking time for what I know are your very busy schedules to further educate yourself on e-discovery and e-discovery issues. Now, a third thing I have learned is that, from my experience over the years, is that as important and critical as e-discovery is, it cannot be allowed to become the tail wagging the dog. What do I mean by that? What do I mean by e-discovery cannot become the tail wagging the dog? Well, let's discuss why a lawsuit is filed very briefly. The reason a lawsuit is filed is to get a result, a conclusion, such as a settlement, a verdict, or a judgment in a civil case. The goal in a civil case is the settlement, verdict, or judgment. The goal in a civil case or in a criminal case is not endless, overbroad, and unnecessary discovery. The purpose of the discovery process is to assist the parties in achieving their goal of concluding the case favorably to their side. It is supposed to be a relatively short process that provides each party with only what is needed, what is relevant and proportional, to prove their case or establish their defense, and nothing more, nothing wasteful or unnecessary. But unfortunately, what can happen in litigation, and what does happen, unfortunately, too often, especially in the e-discovery context, is that the discovery process can overtake the case and become an end in and of itself. It can become a fight, a discovery slugfest in and of itself. It can become the tail wagging the dog. It can overtake the actual case and lead it astray. This causes a waste of attorney and judicial time, clogs dockets, and can cause parties to unnecessarily spend thousands or hundreds of thousands of dollars during the discovery process. This simply should not be the case, and it cannot be the case. To avoid this from happening, to prevent this from happening, discovery must be focused, targeted, precise, and must be related to the issues, the claims and defenses pending in the lawsuit. It must be focused on what the parties really need and not necessarily what they may want or hope for. Interestingly, in all my year of handling and trying tons of cases, it always amazed me that when you get to trial, despite the large volume of discovery exchanged beforehand, it often comes down to only a handful of documents that are really important to the issues in the trial. It is important to understand that counsel need to know what they are looking for in discovery, target it for what they need, and not simply ask for everything under the sun with no regard to whether you really need it or not. And there must be professionalism, cooperation among counsel. During the discovery, the e-discovery process is vital and important. Professionalism and cooperation among counsel is a key to the new paradigm of e-discovery. Over the years, it has seemed that at times that the goal of discovery was to inundate the other side with extensive, overbroad, invasive, far-reaching discovery requests of all types, and to make the discovery process as difficult and costly as possible for the opponent, to let the other side know and fear that they will be buried in discovery, and conversely, to object to the discovery sought in every way humanly possible with numerous boilerplate objections to make it seem like obtaining discovery was akin to pulling teeth. That is the old paradigm of discovery, a discovery slugfest, overbroad, invasive, vague, non-targeted, excessive discovery request, followed by numerous objections, boilerplate objections, vague responses, with the goal to produce as little as possible. The old paradigm of discovery does not work today. It cannot work today. There is just too much data. There is just too much electronic discovery, too much e-discovery. Rather than becoming combative, discovery must be collaborative and cooperative. This requires professionalism and cooperation of counsel. You can still be an effective litigator, a zealous advocate, and nonetheless cooperate as a professional during the e-discovery process. But don't just take my word for it. Several years ago, some very important rule changes dealing with discovery came about in 2015, and Chief Justice Roberts issued his 2015 year-end report, which had some great comments which continue to resonate today. First, he noted that lawyers must size and shape their discovery to the requisites of the specific case. And he said the key here is careful and realistic assessment of actual need. The assessment may, as a practical matter, require the active involvement of a neutral arbiter, the federal judge, to guide decisions interpreting the scope of discovery. Secondly, he noted that the entire legal community, the bench, the bar, the law schools must all step up to meet the goal of Rule 1, Federal Rule of Civil Procedure 1, the speedy, inexpensive determination, the speedy, just, inexpensive determination of every action or proceeding. And third, he made a really interesting comment about lawyers' involvement in the discovery process. And I want you all to think about why you went to law school. And this is what he said. I cannot believe that many members of the bar went to law school because of a burning desire to spend their professional life wearing down opponents with creatively burdensome discovery requests or evading legitimate requests through dilatory tactics. The test for plaintiffs and defendants counsel alike is whether they will affirmatively search out cooperative solutions, chart a cost-effective course of litigation, and assume shared responsibility with opposing counsel to achieve just results. So all of this was the impetus, my experience, all the hearings I've had, everything else was the impetus for me to recently write the law review article that Professor Hamilton referred to, which addresses the new paradigm of e-discovery. That law review article, which will be discussed today at this conference, lists 10 key components, 10 core components of the new discovery paradigm. I will not go through all of those core 10 components now, but I do believe that they are the necessary minimum components of an e-discovery process, which is both fair and equitable to the parties, but is also cost efficient to the clients and not wasteful, does not include wasteful or unnecessary discovery. Some of the key components are targeted and precise discovery requests. Overbroad, general, kitchen sink, any and all discovery requests, that's the old paradigm. Targeted, precise discovery requests, that is the new paradigm. Complete discovery responses, devoid of boilerplate and meritless objection. Sometimes we will see, and we have seen, page after page after page of objections, followed by specific objections, followed by notwithstanding all objections, we're producing something. That's the old paradigm. That does not work. The new paradigm requires responses devoid of boilerplate, devoid of meritless objections. If you have a meritorious objection, state it. If not, state what you're producing, produce the documents, and let's get on to the main show. Let's get on to the summary judgment. Let's get on to the trial. Let's get on to the settlement. Let's not squabble over discovery. You know, this discovery is out there. It's almost impossible to be hidden nowadays. It's going to be uncovered. If it's not on the phone that was destroyed, it's on the backup, or it's in the cloud, or it's in the employer's backup system. It gets found. If it's not one place, it's found somewhere else. The third, and which is a very important, and I think perhaps might even be one of the most important, is professionalism and cooperation and personal conferral when the inevitable discovery dispute arises. Don't be sending nasty emails back and forth. Pick up the phone, go on to Zoom, whatever you have to do. Once this pandemic passes, join your opposing counsel for lunch or breakfast. Discuss these issues. Talk about them like professionals. Most of them can be worked out, and when they can't be worked out, you present them to the court in a logical manner so we can decide whether the privilege issue is appropriate, whether the scope is appropriate. There are legitimate disputes that come up between counsel, but there are also a lot of frivolous disputes that come up. And the new paradigm says no frivolous disputes, only legitimate disputes. And I think another key component is number 10, which is the active participation of judges. I think it's important for judges to take a role in discovery and make sure it doesn't get out of hand. I often refer to it as the fact that if you get a little cut on your finger, You put some Neosporin and a Band-Aid on it, it's going to go away. You get that cut on the finger, you ignore it, it's going to get infected and it's going to get much worse. That's how the discovery process is. Disputes are going to come up. If I can handle them quickly with the aid of good, professional, competent counsel who know what they're doing, it ends the matter. The discovery process can proceed smoothly, and we can move on to the main show in the case. Summary judgment, settlement conference, or trial. That's really what's important. The e-discovery process should be assisting that goal of litigation. So, you know, I've got about a minute left, and I just want to give you some very brief tips as lawyers that appear in court. We're now dealing a lot with Zoom and video conferencing. Just remember that being a zealous advocate, being a good advocate, being able to convince the court and represent your client now involves more than just standing in court and talking. How does your background look? How does your computer sound? How do you appear when you speak to the court? How do you sound to the court? I've handled hundreds of these remote hearings. Some lawyers look great. Some lawyers appear great and sound great. Others, not so much. Are you dressed appropriately? Is your background professional, or is it a bunch of boxes? Is your internet connection strong, and can I hear you? Can you know how to screen share and post a document? These are some tips to think about. I'm sure we'll discuss them more as time goes on this morning in this conference, but I think my time is up now. It's been great speaking to you all, and I look forward today to a really great e-discovery conference where I hope to learn quite a bit more about e-discovery. Bill?
Thank you very much, Judge Matthewman. I really appreciate your comments. Frankly, we also appreciate everything you do on the bench and your leadership.